Hello, and welcome to Disability Rights New Jersey's webinar on informed choice in the vocational rehabilitation setting. We are thrilled that you could join us today. Next slide. My name is Stacy Bissell, and I will be both helping facilitate this webinar and presenting today with my colleague, Susan Head, Senior Advocate and Program Coordinator for the Client Assistance Program, CAP. I am Managing Attorney of our Adult Practice Group. Next slide, please. As quick background on our agency, Disability Rights New Jersey is the designated protection and advocacy agency for New Jersey. We are a nonprofit organization that operates under federal law to advocate for and advance the human, civil, and legal rights of New Jerseyans with disabilities. We do that through monitoring and investigations of abuse and neglect, as well as legal advocacy, outreach, training, education, and more. Next slide, please. A bit of housekeeping today. This webinar is being recorded, and you could add subtitles to your screen by clicking on More, Show Subtitles. Next slide, please. Legal disclaimer. Before we get into the substance of this webinar, a quick note that the information provided is for informational purposes only and does not constitute legal advice. We have also tried to use language that is person-centered and affirms the individual with a disability's rights, but we recognize that the disability community has varied preferences on terminology. Lastly, this area of law uses a lot of acronyms. We do our best to use the entire phrase along with the acronym, but we will use several acronyms consistently throughout this webinar. For example, DVRS for the Division of Vocational Rehabilitation Services, CBVI for the Commission for the Blind and Visually Impaired, and VR for Vocational Rehabilitation. I will pass the baton now to Susan to go over today's learning objectives and to provide a high-level overview of informed choice, including what that means. Next slide, please.
Here are the learning objectives for today's webinar about informed choice and why it is important. We will explain federal law basics, the process to access vocational rehabilitation services, informed choice in the vocational rehabilitation process, what is not informed choice, the role of VR agencies and counselors in informed choice and the appeals process. Next slide. It is the policy of the United States that all activities of state VR programs are to be implemented consistent with the principles of respect for individual dignity, personal responsibility, self-determination, and pursuit of meaningful careers based on informed choice of individuals with disabilities. Because informed choice is such an important concept within the state vocational rehabilitation program, we will look at informed choice requirements from several different perspectives. The concept of informed choice in the VR system is foundational to person-centered service delivery. However, informed choice is a concept that many in the VR programs have difficulty fully understanding and implementing. Nevertheless, it is a requirement under the Rehabilitation Act that applicants and recipients of VR services are active and full partners in the VR process and can make meaningful and informed decisions about the services they need to achieve their career goal.
So why does informed choice matter? Informed choice is so critically important to every part of the VR process, as Susan will discuss again in more detail shortly. Informed choice promotes self-respect and dignity. Informed choice promotes autonomy and empowerment. Similarly, informed choice reduces what we call paternalistic decision-making, When professionals or agencies make or steer decisions for a person with a disability based on what they think is in that person's best interest, rather than treating the person as an active partner in choosing goals, services, and providers. Informed choice aligns services with individual needs, meaning not a one-size-fits-all approach. Remember, informed choice is actually not a choice on the part of the VR agency. Informed choice is the law. What are the statutory and regulatory anchors? Today, we will focus on the federal law that governs VR agency policy and procedure, including when and where those regulations highlight informed choice. We will discuss in detail the Rehabilitation Act, as well as the U.S. Code and Code of Federal Regulations, which has a specific citation on informed consent. Similarly, RSA policy guidance from 2001 further clarifies what is meant by informed consent and how informed consent is implemented. Note, RSA is the Rehabilitation Services Administration, a federal agency. RSA oversees grant programs that assist individuals with disabilities obtain employment. More specifically, RSA provides resources to assist states and other agencies in providing vocational rehab and other services to individuals with disabilities in order to maximize employment, independence, and integration into the community and the competitive labor market. RSA exists within the Department of Education. The Rehabilitation Act, as amended in 2014 by the Workforce Innovation and Opportunity Act, or WIOA, includes the statutory framework for vocational rehabilitation or VR services for people with disabilities. Under the Rehab Act, VR services are state-provided supports and services designed to help people with disabilities prepare for, obtain, keep, regain, or advance in competitive integrated employment, or CIE. CIE refers to work in the competitive labor market where individuals with disabilities earn at or above minimum wage and work alongside their non-disabled peers, receive equivalent benefits, and have equal opportunities for career advancement. Here is a sample of what Congress said in the beginning of the Act as amended in 2014 by WIOA. 1, disability is a natural part of the human experience and in no way diminishes the right of individuals to live independently, enjoy self-determination, make choices, contribute to society, pursue meaningful careers, enjoy full inclusion and integration into American society. 2, increased employment of individuals with disabilities can be achieved through services provided under the VR program established in the Act, which provide meaningful and effective participation in the workforce. Finally, this last bullet is especially powerful. The goals of the nation properly include the goal of providing people with disabilities with the tools necessary to make informed choices and decisions and achieve quality of opportunity, full inclusion and integration in society, employment, independent living, and economic and social self-sufficiency. The Rehab Act allows states to designate 2 agencies to provide statewide VR services. One that provides services to recipients who are blind, and the other that provides services to all other eligible recipients. New Jersey delivers VR services through 2 agencies. The Division of Rehabilitation Services, or DVRS, which is located in the Department of Labor and Workforce Development and is the larger agency that services most VR eligible recipients, and the Commission for the Blind and Visually Impaired, or CBVI, located in the Department of Human Services, which serves individuals who are blind, deafblind, or visually impaired. The Rehab Act, as amended, also establishes 2 other entities that are critically important to people with disabilities who may be qualified to receive services through either DVRS or CBVI. First, the State Rehabilitation Councils for DVRS and CBVI. The purpose of the SRCs is to review, evaluate, and advise VR agencies regarding performance and effectiveness in delivery services, with a focus on achievement of employment outcomes. Each SRC holds 4 quarterly meetings per year, which are open to the public. Disability Rights New Jersey is a statutory member of the SRCs, and we encourage people to attend the meetings. Meeting dates and times can be found on the DVRS and CBVI websites, respectively. Second is the Client Assistance Program, or CAP. The purpose of the CAP is to advise applicants and recipients of their rights to receive services and benefits under the Rehab Act as amended by WIOA, as well as Title I of the Americans with Disabilities Act, the ADA. The CAP provides legal advocacy and representation to VR applicants and recipients regarding VR services. Disability Rights New Jersey is the designated client assistance program for New Jersey. So now let's turn our attention to how the law evolved over time. The Rehab Act of 1973, as amended by WIOA, which makes it clear in its policy statement that all programs, projects, and activities funded under the Rehabilitation Act, including the VR program under Title I, must be, quote, carried out in a manner consistent with the principles of respect for individual dignity, personal responsibility, self-determination, and pursuit of meaningful careers based on informed choice of individuals with disabilities. The Rehab Act amendments introduced the principle of informed choice into the statute and provided individuals with disabilities expanded opportunities for increased involvement in the direction of their VR programming. The Rehabilitation Act amendments also strengthened the previous requirements related to informed choice and introduced additional requirements that expand opportunities for increased participation of individuals with disabilities in developing and implementing their VR programs. This policy is reinforced in Section 100A(3)(c) of the Rehab Act, which states that the state VR program must be carried out in a manner consistent with the following principle. Individuals who are applicants for such programs or eligible to participate in such programs must be active and full partners in the VR process, make meaningful and informed choices, 1, during assessments for determining eligibility and VR needs, and 2, in the selection of employment outcomes for individuals, services needed to achieve the outcomes, entities providing such services, and the methods used to secure such services. This requirement for informed choice can be found in 34 CFR Section 361.52 and reflect the statutory language used in the Rehabilitation Act. More specifically, part of the code reiterates the general requirements that the VR agency must provide information and support services needed by applicants for and recipients of VR services in exercising informed choice throughout the rehabilitation process. Further, Part B explains that the VR agency, in consultation with the SRC, if there is a council, must develop and implement written policies and procedures that enable an applicant or recipient of services to exercise informed choice throughout the VR process. At a minimum, these policies and procedures must provide for the following. 1, informing each applicant and recipient of services, including students with disabilities and youth with disabilities, about the availability of and opportunities to exercise informed choice throughout the VR process. Such information must be provided using appropriate modes of communication to meet the specific needs of the individuals with disabilities. Individuals with cognitive or other disabilities who require assistance in exercising informed choice must also be informed about the availability of support services to assist them in their decision-making process. 2, assisting applicants and recipients of services in exercising informed choice in decisions related to the provision of assessment services. 3, developing and implementing flexible procurement policies and methods that facilitate the provision of VR services and that afford recipients of services meaningful choices among the methods used to procure VR services, And finally, 4, assisting eligible individuals or, as appropriate, the individual's representatives in acquiring information that enables them to exercise informed choice in the development of their individualized plan for employment, or IPE, with respect to the selection of the following: employment outcome, specific VR services needed to achieve the employment outcome, entity that will provide the services, employment setting and the settings in which the services will be provided, and the methods available for procuring the services. Susan will speak further about the pre-IPE and IPE process shortly, as well as the process to access VR services. Now back to you, Susan.
Thank you. The application process for VR services begins with a completed and signed application form. While the federal regulations require VR agencies to make application forms available at one-stop career centers, the process to apply for VR services in New Jersey is typically initiated by contacting the agency directly or by submitting a referral form. State VR agencies are required to develop standards for prompt and equitable handling of referrals, as well as timelines for making good faith efforts to inform individuals referred of application requirements, including the information and documentation necessary. The Division of Vocational Rehabilitation Services, or DVRS, which is New Jersey's general VR agency, recently reported that the time frame between a referral and an application appointment with a VR counselor is typically 1 week. The referral form for DVRS services is located on the DVRS website and can also be accessed via the link below. To apply for vocational rehabilitation services from the Commission for the Blind and Visually Impaired, or CBVI, the individual or their representative may contact CBVI by phone or email to begin the application process. The contact information for CBVI is on their website and can be accessed via the link below. Generally, the VR agency must make an eligibility decision within 60 days. Once eligibility has been established, the VR agency has up to 90 days to develop the IPE. The Individualized Plan for Employment, or IPE, is an important document that defines the services the VR agency agrees to provide the eligible individual. The IPE is not a contract, but it has significant weight if disagreements occur. The IPE must be reviewed at least annually, and if necessary, amended if there are significant changes to the employment goal, the VR services to be provided, or service providers. Changes to the IPE do not take effect until agreed to by the individual and their VR counselor. Basic components of the IPE include the employment goal chosen by the individual, the VR services to be provided. These may include any service necessary for the individual to achieve their employment goal, including but not limited to assistive technology, funding for college, transportation, interpreter services, occupational licenses, tools, rehabilitation technology, technical assistance to develop business plans, personal assistance services, or other goods and services determined necessary for the individual to achieve their employment goal. The IPE also documents the timeline for when services start and end, the entity providing services, and the responsibility for the cost of the services. The IPE does not take effect until it is agreed to and signed by the eligible individual and approved and signed by the VR counselor. To ensure the applicant an eligible individual can exercise informed choice in the VR process, including in the development of the IPE, the VR agency must provide information about services and service providers, which may include the following information: the cost, accessibility, and duration of potential services, consumer satisfaction with those services to the extent that such information is available, the qualifications of potential service providers, the types of services offered by the providers, the degree to which services are provided in integrated settings, and the outcomes achieved by individuals working with service providers to the extent that such information is available. The VR agency must provide information about the opportunity for the applicant to exercise informed choice throughout the rehabilitation process, including at the time of application and during the eligibility process. For example, if sufficient information is not available to determine eligibility and identify the services the applicant may need, the VR counsellor may recommend an assessment. In this case, the applicant should be given the information necessary to make an informed decision about the assessment. This may include the VR counsellor providing a list of service providers with contact information to enable the applicant to obtain more information about the assessment and to select the assessment provider of their choice. Informed choice in assessment services would not involve the VR counsellor selecting the assessment provider or failing to provide the individual with a choice of providers. After the VR agency determines eligibility, the VR agency has up to 90 days to work with the individual to develop an individualized plan for employment, documenting the individual's selected employment goal and services needed for the individual to achieve their goal. At any point in the VR process, the eligible individual may discuss with their VR counsellor the services needed to achieve their employment goal. At the pre-IPE meeting, the VR counsellor may request additional information about the individual's employment goal and the services needed to achieve the goal. As the slide indicates, the meeting may be virtual or in person. Informed choice and the IPE go hand in hand. The IPE must be developed and implemented in a manner that gives eligible individuals the opportunity to exercise informed choice. To ensure informed choice, the VR agency must assist the individual acquire the information necessary with respect to selecting the employment goal, the employment setting, the specific vocational rehabilitation services needed to achieve the employment outcome, including the settings in which services will be provided, and the entity or entities that will provide the vocational rehabilitation services. As this slide indicates, the 1998 amendments to the Rehabilitation Act stipulate that the employment goal must be chosen by the individual and must be consistent with the strengths, resources, priorities, concerns, abilities, capabilities, interests, and informed choice of the individual. It is important to note that the employment goal selected by the individual must be consistent with the individual's strengths described above, as the primary objective of the VR system is employment. And when the VR agency evaluates the employment goals selected by the individual, they will need to find that there is some likelihood that the selected employment goal will lead to a viable employment outcome. Here are the options to develop the IPE. Informed choice means the VR agency provides the individual with information about the various options for developing the IPE, including the option for the individual or their representative to develop all or part of the IPE with assistance from the VR counsellor, without assistance of the VR counsellor, or with the assistance from a disability advocacy organisation. The individual decides the level of involvement, if any, of the VR counsellor in developing the IPE. However, because the VR agency must approve the IPE, the individual may decide to collaborate with the VR counsellor on the development of their IPE in most instances. Here are some examples we see in our practice when informed choice is denied in the VR process. The VR counsellor selecting the individual's employment goal or pressuring the individual to agree to a goal they have not selected. The VR agency denies the individual's request for an advanced employment goal, even though the goal aligns with the individual's abilities and interests. Information necessary to enable the individual to make informed decisions is not provided. The VR agency responds to a requested service with a blanket denial without exploring the individual's needs. Forwarding the individual a completed IPE developed without full consultation and collaboration with the individual. Now back to Stacey to speak about informed choice, guardianship, and related matters.
Thank you, Susan. Guardianship and informed choice. Even if an individual with a disability has a guardian, they still have the right to informed choice. The ARC has emphasized that individuals with intellectual and developmental disabilities have the right to informed choice in the vocational rehabilitation context, even when under guardianship. The guardian shall encourage the person to participate to the maximum extent of the person's abilities in all decisions that affect them. Likewise, the guardian shall, wherever possible, seek to ensure that the person leads the planning process and, at a minimum, to ensure that the person participates in the process. Choice and individuals with significant disabilities. As has been discussed at length today, the concept of informed choice in the VR process is foundational to person-centered service delivery. Informed choice means that an individual with a disability is an active partner who directs the decisions in the VR process. This is no different for a person with significant disabilities. Every VR recipient has a right to informed choice, and for those with significant disabilities, this may mean that they may need more supports and services to exercise their right to informed decision-making, but it does not diminish their right to informed choice. The CFR specifically requires VR agencies to inform individuals with cognitive or other disabilities who require assistance in exercising informed choice about the availability of support services throughout the rehabilitation process. Client profiles. These client profiles are not based on specific individuals, but they represent fact patterns we see regularly in our practice. Jamal. Jamal, who was diagnosed with generalized anxiety disorder and depression, was advised by his high school guidance counselor to contact the state VR agency to discuss support for his selected employment goal of pharmacist. Jamal has exceptional grades and strong SAT scores and is ready to apply to pharmacy schools in New Jersey. The VR agency informed Jamal that they would not support the employment goal of pharmacist, but would instead support the goal of pharmacy technician. The VR agency did not inform Jamal about his right to request a waiver or exception of the denial or provide him with written notice on how he could appeal the denial. Now let's talk more about Jamal and the denial by the state VR agency of his employment goal. A major barrier for VR recipients to pursue advanced level professional careers is a presumption by the VR agency that they should pursue a less advanced employment goal. Jamal has the ability to pursue pharmacy, assuming acceptance into the program, but the VR agency is encouraging him to pursue a less advanced goal. This is a violation of informed choice. Informed choice, which indicates that the IPE be developed and implemented in a manner that affords eligible individuals the opportunity to exercise informed choice in selecting an employment outcome. In this scenario, the VR agency may advise Jamal that after completing the pharmacy technician training, they could amend the IPE to include support for pharmacy school. However, while the federal regulations make clear that the VR agencies can and should assist individuals advance in employment without a signed IPE documenting the advanced career goal, there is no guarantee the VR agency will support the advanced goal at a later date. Given these facts, Jamal would need to decide whether to accept the VR offer to pursue pharmacy technician training in lieu of pharmacy school or appeal the decision. We'll discuss how to appeal VR decisions shortly.
And here we have another scenario involving an applicant of VR services. Jackie, who is diagnosed with neurological impairments and mental illness, met with a VR counselor to sign an application for services. At the meeting, Jackie explained she wanted to start her own food truck business selling gourmet tacos and asked the counselor how the VR agency could assist her develop her own business. The VR counselor informed Jackie that it was too early in the process to discuss an employment goal, as they needed information from her medical providers to ensure she was cleared to pursue employment. Jackie explained she would like a family member to join her at future meetings to help answer questions. The VR counselor advised that it was not necessary for a family member to participate in meetings unless they were the legal guardian. In this example, Jackie meets the VR counselor for the first time and wants to discuss her vocational interest in starting her own food truck business. Generally, it is the responsibility of the VR counselor to inform the individual about the available options to exercise informed choice and ensure that the individual understands the options. Here we see problems with a lack of informed choice, because even though it is early in the VR process and Jackie is meeting with a counselor to complete the application for services, for Jackie to be able to exercise informed choice in the process, she needed information. Instead of advising Jackie it was too early in the process to discuss employment goals, the VR counselor could have provided Jackie with information about the agency's policy on self-employment and information on the services available from small business associations and how to contact them. An additional issue here is the denial by the counselor of Jackie's request to have a family member participate in DVR meetings. Informed choice means that applicants and recipients receive the support, information, and technical assistance necessary to make informed decisions about various options and services, including, to the extent necessary, having a family member participate in the VR process. Here are some of the responsibilities of the VR counselor to ensure that VR applicants and recipients can exercise informed choice. This includes providing the information and support necessary to enable the individual to make informed decisions about the services they receive. This may include informing the individual how they can exercise informed choice, assisting the individual obtain information, supporting the individual in making decisions, encouraging the participation of family members if needed, informing the individual about options to develop the IPE, and if requested, facilitate development of the IPE. VR agencies have a responsibility to implement policies, procedures, and practices, and to develop resources that enable applicants and individuals eligible for VR services to exercise informed choice throughout the VR process. These policies, procedures, and practices must be consistent with federal, statutory, and regulatory requirements. Stacey will now take us through the rights of VR applicants and recipients who are dissatisfied with a VR agency's decision.
VR due process rights. For our final topic of the webinar, we are going to discuss due process rights under the Rehab Act as amended by WIOA. These rights are statutory, and while comprehensive and strong, they are not constitutional rights like those afforded to Medicaid recipients. When I say due process, it may be easier to think about administrative fair hearing. Statutory due process or appeal rights means that the government must act fairly and follow certain procedures like written notice and the opportunity for a hearing before taking an adverse action against an applicant or recipient of VR services. Under the Rehab Act, as amended by WIOA, VR applicants and recipients who are dissatisfied with a VR agency determination that affects the provision services have several important statutory due process rights, which we will discuss in turn. The right to receive written notice at key moments in the VR process, including the denial of VR eligibility and termination of services as examples. The right to appeal an agency's determination through both informal and formal channels, and the right to appeal a final agency decision to the New Jersey Superior Court, Appellate Division, or federal court. So when does an applicant for VR services or a recipient of VR services have due process rights? An applicant for VR services and recipient of VR services have the right to receive written notice and access the appeals process when, first, they apply for VR services. Note, the Rehab Act as amended is clear that when the VR agency determines that an applicant is ineligible for VR services or that a recipient is no longer eligible, the VR agency must inform the individual in writing of the ineligibility determination, including the reason for the determination, as well as the appeals process to challenge that denial. Second, they are assigned to the state's order of selection. Note, there's an asterisk here because we do not have an order of selection currently in New Jersey. Third, when an individualized plan for employment or IPE is developed. And lastly, whenever VR services are reduced, suspended, or terminated. Next slide. Federal law requires that state VR agencies provide written notice to VR applicants and service recipients of the following: the right to appeal an agency determination through an impartial due process hearing, more commonly called a fair hearing, in New Jersey administrative courts, the right to request mediation. Important to note here, neither DVRS or CBVI currently have a working mediation mechanism. So mediation, though required by federal law, is not an option for VR applicants or recipients at this time. The names and addresses to file a request for mediation or a fair hearing, the manner in which a mediator or an impartial hearing officer, which we call an administrative law judge or ALJ, will be selected, and information about the Client Assistance Program, CAP. If the VR agency has an informal process for resolving an appeal, written notice should include information about accessing that process. Important to note that the informal process must not be used to deny an impartial hearing or mediation, and if the informal process is not successful in resolving the dispute, the VR applicant or recipient must have access to the formal hearing process, and it must be conducted within the period specified under federal law. The federal law also makes clear that in most circumstances, a VR agency may not begin a suspension, reduction, or termination of VR services, including evaluations or assessments for eligibility or development of the individualized plan for employment, pending a resolution of the administrative fair hearing. We turn now to the three appeals processes. First, informal dispute resolution. Federal law permits but does not require an informal process. Important to note that where an informal process is offered, the formal fair hearing must still occur in the regular statutory time if the informal process is not successful. Both DVRS and CBVI offer the informal process. Impartial due process hearing. Both DVRS and CBVI use New Jersey's administrative fair hearing to meet this federal requirement. The hearing must be held within 60 days of the applicant's or recipient's request for the hearing. At the fair hearing, applicants or recipients have the right to present evidence in support of their position. They have the right to present witnesses as well as examine all witnesses presented, and the right to be represented by counsel, including by Disability Right New Jersey's CAP program. Under federal law, the ALJ's decision is final unless the state has established procedures, preferably by regulation, to seek review by the head of the designated state agency, the Department of Labor for DVRS or the Department of Human Services for CBVI, or an official from the governor's office. There is a bit of confusion about this in New Jersey right now because of a very old expired regulation. So if you disagree with the ALJ's decision, it may be handled one way by DVRS as a final agency decision and another way by CBVI as an initial agency decision subject to review. Regardless, an applicant or recipient always has the right to appeal an adverse decision to the New Jersey Appellate Division or the District Court of New Jersey. You can find more information about the appeals process on our website, that same link that was provided above. This concludes our presentation. Thank you so much for attending, and we hope you have enjoyed. The next few slides provide information on DRNJ's location, how to access our self-advocacy resource center, as well as our address and phone number and email address. Thank you so much again for your time. We hope that you have learned a lot about informed choice. Take care.